What's up, everyone? It's the Law School Lumberjack. I'm here with another installment of our Contracts 101 series. Today we're going to be talking about the difference between void, ab initio, and voidable contracts. Now, I'm just going to give a brief primer on both of them and when they show up and the effect of both of these types of contracts. In future videos, we may go into more detail on this subject, but because it can be a confusing topic for students, I thought I would give a primer on the difference between these two in order to give some assistance moving forward. So without further ado, let's go into the easier of the two, void ab initio contracts. Now, a void ab initio contract is a contract that is void or is unenforceable from the very start. So as you know, contracts have some basic elements, things such as offer, acceptance, consideration, capacity, legality, and consensus ad idem, to name a few. If it becomes apparent that one of these central elements are missing from a contract, for example, the contract will usually be held to be void ab initio, or basically that it didn't exist from the start. So, for example, if you have something that fails the legality portion of the contract's elements and is illegal, then you will likely have a situation where the contract is unenforceable. Now, a voidable contract is a contract that usually has all of the elements of the contract, but there is some other vitiating circumstance that allows that contract to be repudiated. Now, where you see this voidable contract is in situations where there's undue influence, duress, some sort of usually a mistake, or some unconscionable fact scenario that makes it unfair for the court to enforce that contract. Now, you might be wondering, what's the big difference between these two and why is there a distinction? So in practice, the two main differences between a void ab initio contract and a voidable contract are as such. Firstly, we come to standing to challenge the contract. So with a void ab initio contract, either party to the contract can challenge it for being void ab initio. So let's say, I always use Abe and Bob in my example. So let's say Abe and Bob enter into a contract and Bob purchases something illegal from Abe and Abe gets money from Bob. Now, because this contract is for an illegal item, the contract can be held to be void ab initio. Now, because it's a contract that can be held to be void ab initio, either Abe or Bob can go to court for a declaration that the contract is essentially null and void. Now, conversely, with a voidable contract, only the party who is aggrieved can go to court for a declaration that the contract is unenforceable or void. So let's use an example in this circumstance, again with Abe and Bob. So let's say Abe knows that Bob is in a situation where he really needs money, and Abe takes advantage of that, and it's a clear case, let's say, of financial duress. Obviously, we'll go into duress in more detail in another video, but let's, for the sake of just explanation, just say Abe took advantage of Bob. In that circumstance, the contract is likely voidable. It's not void from the start, but it would arguably be voidable, and the court may hold, at their discretion, that the contract is unenforceable. However, Bob is the only one who can bring a challenge to that contract. So if for some reason, even though Abe takes advantage of Bob, Bob ends up finding out that the contract benefits him, Abe can't go to court for a declaration that the contract is unenforceable on the grounds that there is financial duress. Only the party who is aggrieved, being Bob, can bring that claim. So that's the first difference between a void ab initio and a voidable contract. The second one is a bit more tricky and comes into play when there's multiple stages of a contract or there's some damages with respect to a contract. And that is, a void ab initio contract is void from the start. So there can be no part performance of that contract. Basically what happens is, if that contract is found to be void ab initio and the court agrees, the entire contract is unwound. Conversely, with a voidable contract, usually what happens is it's void from the point that the court declares that that contract is unenforceable. So let's say there's a two-part contract, let's say to build an apartment building, for example. Two parties agree, let's say Abe and Bob. Again, let's assume that Abe took advantage of Bob and there's financial duress, but Bob agreed that after certain amounts of concrete were laid, he'd pay a certain amount of money, and then upon completion of the apartment building, Bob would pay the remaining sum that was due and owing to Abe. So let's say Abe completes part A and the partial sum is provided to Abe, but right after A is completed, Bob then goes to court and gets a declaration that the voidable contract is unenforceable. Unlike with a void ab initio contract, where basically the contract gets unwound, with the voidable contract, part performance, or the part performance that has actually occurred to date, will be valid, but once the court finds the contract to be unenforceable, from that point forward, the contract will have no effect. I hope this video was helpful. If you have any questions, please feel free to comment below. If this video was helpful, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.